Okay. Very good evening, everyone. Okay, good evening, students. So, first of all, I welcome each one of you to my class on the limitation for taking cognizance of certain offenses. So, let's start with my brief introduction first. My name is Sandeep Khatri. My areas of specialization, as you can see on the screen as well, the constitutional law, the criminal law, commercial laws, family laws, jurisprudence, and law of torts. Students, I have shared the link of my profile of Unacademy, so make sure you follow that to get all the updates about my special classes and my plus courses. I have shared the link of my Telegram channel as well, in which you can connect with me and ask your questions in relation to your judicial preparation. At last, I have mentioned my code Khatri10, which you can use to get free access of all the special classes available on Unacademy app. So this was about me. Now I request everyone, please be attentive, and this is going to be interactive session. So the moment you feel you are not clear with anything, feel free to ask your questions in the comments and I'll answer accordingly. So today we are going to solve some of the most important MCQs when it comes to chapter number 36. So if you have any question before starting the session, you may ask, and if not, quickly give me a thumbs up. I'll straight away start with the MCQs. Yes, any questions? Okay. So let's begin with the very first question. The bar of taking cognizance and after lapse of the period of limitation under section. So one of the most important section from this chapter, that is chapter number 36, which is actually, barring to take the cognizance. So the magistrate will not be able to take the cognizance if the case falls under which section? 'Yes, answer to this question. From which section number this concept has been? And the answer to this question is, students, B, that is section 468, that basically giving you the bar to take the cognizance after the lapse of period of limitation. So B is the correct answer, 468. Moving to the next one. If the period of limitation shall be, now what is going to be the period of limitation if the offense is punishable with fine only? Choose the most appropriate option. Six months, 1 year, 3 years, 2 years. So in that case, the correct answer is A, that is basically 6 months. So if the offense is punishable with fine only, then if the magistrate cannot take the cognizance after 6 months, as per to, again, back to section number 468. Now coming to question number third. The period of limitation shall be dash if the offense is punishable with imprisonment for 6 months. 'So, if the offense is punishable with imprisonment for 6 months, then The period of limitation shall be, that is B, which is 1 year. So B is the correct answer. Coming to the next one. Very good evening, Neha and everyone, those of you who have just joined. Question number 4th. The period of limitation shall be dash if the offense is punishable with imprisonment for 2 years. Then what is going to be the period of limitation? Choose the most appropriate option. Correct answer, Neha, followed by Himanshi. Yes, C, that is 3 years, is the correct answer, students. So this is again as per to section 468. Okay, so basically to learn this, you can easily make a chart. So in case if the offense is punishable with fine only, then it is going to be 6 months. If it is less than 1 year, then it is going to be your 1 year. And if it is going to be exceeding 1 year, but less than 3 years, which is basically 2 years in my case, then the answer is going to be 3 years. Next one. Commencement of period of limitation under section. So we do have a specific section number from which part, from exactly at what date the period of limitation will be commenced. So that is mentioned under section. Good evening, law student and everyone, those of you who have just joined. First one to answer correctly, D, by the law student. And yes, D is the correct answer, students. Section 469 basically tells you the date of the commencement of the period of limitation. Himanshi, correct answer. Next. In computing the said period, which is basically we are talking about period of limitation here, the day from which such period is to be computed shall be the first day, shall be admitted, included, excluded, none of the above. Choose the most appropriate option. Okay, top 3 students to answer correctly. Neha, Himanshi, law student, basketball skills. Okay, everyone's answer is correct. That is basically C, that it is going to be excluded. So C is your correct answer. Where the period of limitation expires on a day when the court is closed, the court may take cognizance. Choose the most appropriate option. Top 3 students to answer correctly, law student followed by Himanshi, Pushparaj. Okay, no. Neha. Law student Himanshi and Neha. Pushparaj, please do correct your answer. The correct answer is on the day on which the court reopens. Now, can anyone tell me the reasoning behind that? Why? Why so? Why on the day on which court reopens? The D is the correct answer. But if you can tell me the reasoning behind that. Anyone? because the working day is counted. Okay, let me give you just one simple example here, students. Let's assume that the 20th of December is the last date where period of limitation expires. And suppose if the 20th of December is Sunday. Now, in that scenario, on the day on which the court reopens, then you will get the extension. Okay, so that is the idea. Next one. Continuing offense. Correct answer, Himanshi. And correct answer, law student. So continuing offense under section dash for the period of limitation. Okay, I have two important questions in reference to this question. First, you answer question number 8, and after that, I'll come up with those questions. Sumati, please do correct your answer for question number 7. D was the correct answer. Okay. Okay. Law student and Himanshi, correct answer. Section 472 is basically talking about continuing offense. Now answer this. Is there any difference between these two concepts, continuing offense and inchoate offenses? Yes, please. They are synonyms or they are different offenses? Continuing offense and inchoate offenses. Yes, anyone? It's not that difficult. Continuing offense and inchoate offenses are synonyms or they are two completely different concepts. Okay, Himanshi. Okay, let me tell you, students, these two are completely two different offenses. Okay, inchoate offenses are basically incomplete offenses. Okay, and continuing offenses are which are you are doing for each and every second. Okay, so that is basically your continuing offense. Okay, so that is your 472. Next one. In case of continuing offense, the period of limitation is good evening, Padma, and everyone, those of you who have just joined. Okay, Manshi, I'll go in the detail. First, you answer this one, and after that I'll explain in detail. Okay. Okay, starting from Padma, law student, Nawab, Pushp, and Akash. Everyone's answer is correct, and that is a fresh period of limitation shall begin to run at every moment of the time during which the offense continues. Everyone's answer is correct. Now let me explain this concept in detail. Listen this carefully, students. This is important. See, there are two kinds of offenses here. One is continuing offenses. And the second one is inchoate offenses. Now, first understand what is inchoate offenses. Inchoate offenses are basically which are incomplete. Now, how they are incomplete? Let's understand this with the help of some examples. Now, let's take an example of attempt. Now, suppose attempt to murder. Can we say that is a complete offense? No. because the intention was to commit the murder. So we will call that whatever attempt it is, attempt to murder or attempt to any particular offense, that is going to be treated as inchoate offenses. Okay, let's understand the second one. Criminal conspiracy. When it comes to criminal conspiracy, that is itself is an offense under section 120A, which is punishable under section 120B. For attempt, you have section 511 of IPC. Okay. Now coming to criminal conspiracy is itself in an offense. But suppose you are doing criminal conspiracy for murder. So for that, criminal conspiracy is incomplete. Again, inchoate offense. Okay. Coming to the last example now. When it comes to abatement, section 107, when someone is abating an offense, what is that? That is again incomplete, because the overall objective is, suppose there is abatement of murder. So murder is the complete offense, but abatement of murder is an inchoate offense. So these are the example of inchoate offense. Basically, the key word here is to remember is incomplete, and these are the examples. Okay. Always do remember, students, kidnapping, okay, is not an inchoate offense. Okay. Now moving to the next one. Now what is continuing offense? Basically, which is not ending. Which is not ending. Let's take some examples now. Abduction. When you will read the concept of abduction, taking one person from one place to another. Now from which place to which one? So that is why we call abduction is a continuing offense. Okay. Second one you can take is domestic violence. You can take an example of domestic violence as well. So for example, the husband is beating his wife on a daily basis. So that is something he is doing, continuingly. Okay, so that is also a good example of continuing offense. Always do remember, kidnapping from India or kidnapping from lawful guardianship, they both will not fall into the category of continuing offense. Why not? There is a reason behind that. And the reason is, the moment you took that person out of the country, kidnapping from India completes. Done. Similarly, when it comes to kidnapping from lawful guardianship, the moment you take that person out of the lawful guardianship, for example, out of his home or out of his school, okay, that particular moment only you have committed the offense, and that is complete kidnapping from lawful guardianship. I hope now it is clear. They two are separate concepts: continuing offense and inchoate offenses. If you still have any doubts, you may ask in the comments, or I'll continue with the MCQs. Himanshi, clear? Waiting for your thumbs ups. Okay, ji. Thank you very much. So moving to the next question. A court shall be deemed to be closed on any day within the meaning of this section if dash it remains closed on that day. So choose the most appropriate option. See, if you have read Bayer Act, if you have gone through with these sections, these questions must be very easy for you. Law student Padma Himanshi, correct answer. During its normal working hours, there is no time specification that has been given. So during its normal working hours, if the court is closed, okay, even for 1 hour, that will be, it remain closed for that particular day. Okay. Let me give you one practical example of this as well. During the time of strikes usually, okay, so that is where actually the timing of the court got affected because of the strikes. And in that situation, if because of strike, if for 1 hour or for 2 hours the court was not open, then it will be consider that it has been remained closed for that particular day. Any court may take cognizance of an offence even after the expiry of the period of limitation if it is satisfied. Okay, when you will read this section starts with notwithstanding, which means this particular section has an overriding effect over all the provisions. Okay, so and in the circumstances of the case that the delay has been properly explained or that it is necessary to do in the interest of justice. So this is under section. Tejaswani, first one to answer correctly, followed by law student and Himanshi. Everyone's answer is correct. This is basically your last section from this chapter. Okay, and that is 473. Okay, the last section, obsolete clause. The term period of limitation defined under section. बताइए जी. Period of limitation defined under section. Wow, I have got 3 answers and all are different ones. Padma, B. Law student, D. Tejaswani, D. पुष्पराज, D. ऐसा कैसे चलेगा? I have not received the correct answer till now. Last opportunity. Come on, it's not that difficult. I have not received even a single correct answer. Students, this term period of limitation has been defined, and that is under section 467 definitions. Tejaswani, correct answer, C. Pushparaj, C. Padma, C. Yes. Period of limitation defined under section 467. Mind it, when you are going to read 467, that will take you to 468. But again, you cannot say that the term has not been defined. Okay? It is like whether the term metropolitan area has been defined or not. So we do have a particular section, that is section number 8. But still, you will for the answer to this question whether this term has been defined or not, you will refer section 2K. Okay. So the same relationship will be shared with section 467 and 468. So the correct answer is going to be 467. Now I have one more interesting question in association with this concept, and that is, see, when you read this term period of limitation, I hope everyone goes into the concepts of period of limitation act. So limitation act, can you apply limitation act to CRPC? Answer in the comments, yes or no. Can you apply limitation act to CRPC? Yes or no? Okay, Pushparaj, first one to answer no. Padma, no. Yes, up till 3 years offense. Tejaswani. Okay. Tejaswani, please do correct yourself. When it comes to the Limitation Act, that will be applied only to CPC, that is the civil proceeding. As far as the period of limitation is concerned, for for the CRPC, then we do have a specific chapter, that is chapter number 36. The whole purpose of chapter 36 is that only, that for the app, why we are going for the definition of period of limitation to 467, and why not to the section number 2 of Limitation Act. The answer is because Limitation Act has no application to CRPC. Okay, so that is the idea. Next one. The term cognizance defined under section. Tejaswani, please rephrase your question. What actually you want to ask? Your statement says, please reply 468 then. So please do rephrase that, whatever you want to ask, and I'll answer accordingly. Sumati, only student. Okay, Sumati followed by law student. Okay, so D is the correct answer. Students, this term cognizance has not been defined. Okay, 2C define the term cognizable offense or cognizable case. Section 468 does not define cognizance. Okay, it gives you the period of limitation in different cases. Section 154 is information of cognizable offenses. So the correct answer here is D, not defined. Okay. चलिए. Limitation for taking cognizance of certain offenses under chapter. In this class itself, I have repeated many times. So you can easily answer the chapter number. Okay, Tejaswani, I have got your question. So let me complete this one and after that I'll answer now. Now I have got your question. Top 3 students to answer correctly, Tejaswani, Himanshi, and law student. Correct answer. Padma and Nasifa, please do correct yourself. Students, there are only 37, total 37 chapters when it comes to CRPC. This one is the second last, which is basically 36. So B is the correct answer. Chapter number 36 deals with limitation for taking cognizance of certain offenses. Okay. Now I am answering your question, Tejaswani. Okay. See, when it comes to the Limitation Act, okay, its application is on CPC. That is your basically civil proceedings. What is the purpose? Try to understand the object. Okay. The object of Limitation Act is that if there is, suppose I'm just taking one simple example, if there is a contract between two parties and one of the party committed the breach. Okay. Let's take an example. There are two parties, A and B, and they are having a contract. Now B is the one who has committed breach of contract. Now A has all the rights to file a suit against B, okay? Because B has committed breach of contract. So now when will A file a suit? So there must be a time limit or not. And there comes the role of Limitation Act. So Limitation Act will tell, okay, you may file the suit, but there is going to be 3 years, which is basically more than sufficient time. So within those 3 years, whenever you are free, whenever you are willing to file a suit against B, you may do so. Okay, so 3 years is much sufficient time for any particular individual. But after 3 years, the Limitation Act will stop Mr. A from filing the suit. Okay. Now coming to this one. Now let's take an example. If A has committed an offense, okay, under IPC or any special law for that matter, okay. Now coming to this, if A successfully, okay, uh, If suppose no one has reported that, so suppose no FIR has been lodged, okay, no complaint to magistrate, no information to magistrate, no suo moto, so basically no one has taken the cognizance. And even after, so suppose if that is the case of murder, if A has committed the offense of murder, but no FIR, no complaint to magistrate, no information, no suo moto, no one has taken the cognizance. And in this particular situation, if after 50 years down the line, if we got to know about that, ki, okay, this Mr. A has committed one offense, can we apply limitation act on this one? So the answer is no. A complete no. Limitation act is for CPC. Now coming to for CRPC, when it comes to the application of CRPC, we do have a separate chapter. That is chapter number 36. So chapter number 36 has nothing to do with the Limitation Act. You can see even the term period of limitation has also been defined in this chapter. Okay, section 467. So if that was the application of Limitation Act, there was no need to define the term again. Okay, so chapter 36 is basically for the offenses if the punishment is less than 3 years, then there is a period of limitation. But if the punishment is more than 3 years, then there is no period of limitation for those particular offenses. I hope now it's completely clear. And if you still have any doubts, do write your questions in the comments and I'll answer. Okay, Tejaswani. Done. Chaliye. Coming to the last question, here it is. Which of the following time is including while calculating period of limitation? Choose the most appropriate option. Padma, law student, and Tejaswani. No one has read the question carefully. Read the question again. Which of the following time is including the time during which the offender has been absent from India? This is something which is going to be excluded. The time during which the offender has avoided the arrest, this is going to be excluded. So the answer is going to be D, none of the above. So what you have learned, that always read the question carefully. This is including. If the question was which of the following time is excluding while calculating the period of limitation, then the answer is going to be both A and B. But if it is including, then the answer is going to be none of the above. Okay. Chaliye ji. Now anything which you are not clear with before concluding the session? Yes, please. So this is the link of my profile, my Telegram channel, and this is my code Khatri10. Students, if you are preparing for UP Judiciary exam, I have already covered the special laws, the 3 special laws so far. No, 4. 4 special laws I have already covered. So you can visit my profile and everything is available on in a special class. So that is completely free of cost. All you need to do is just use this code, and there are 2 classes I have taken on each law. The one is basically on the explanation side, and then the MCQs, the most important MCQs from that particular special law. So you can take that as well. Law students, how to remember judgments of constitution? See, when it comes to the judgment of constitution, try to recall the story. Okay, try to attach the story with every case law. Okay, that trick may help you, right? So you can do that. Uh, when it comes to constitution of India, for each and every article, even when it comes to landmark judgments, the number is huge. Okay, I hope that's why only you are facing the issue. So what you can do is just limit your resources. Okay, don't go for more than 4 or 5 judgments on a particular topic. And that is again, okay, let me give you, as far as your fundamental rights are concerned, 2 to 3 judgments are more than sufficient. Okay, there is only one article, that is your article number. For Article 13, you can go for 8 to 9, all the judgments you have to do. Except that article, just go with 2 or maximum 3 judgments only. Okay. So if you are going to lower your number of judgments, that is going to be easy for you. Okay. Tejaswani, in CPC, judgments are not that important. The concepts are. Okay. The another name of constitution is the landmark judgments. Okay. There are many judgments when it comes to Constitution of India, but not in the case of CPC. In CPC, when it comes to the list of landmark judgments, I guess that will not exceed more than 15 or max to max 20, I guess. When it comes to landmark judgments, not like the judgments on every each and every topic. You can find judgment on each and every topic, but when it comes to landmark judgments, the core judgment, the most important ones, that actually has given the guidelines, or which has matlab, like changed the whole concept, that is not more than 20. uh Tejaswani, answer to your question, section and order, I can understand, but see, this is what it is. And what you can do is, whatever state you are preparing for, okay, whatever state you are preparing for, just go through with the previous year question papers and see what are the orders, what are the rules, okay, what are the sections that has come repeatedly in your exams. That may lower your burden. Okay, you don't need to go through with each, you don't need to remember, all the orders with the rule numbers. Okay, there are important ones, there are most important ones, and there are many which you may ignore, or you can put in the list of one time read only. Okay, chaliye ji. So let's crack PCS J with Unacademy. So there's a rapid revision for UP and Chhattisgarh Judiciary batch started from December 20th. Prarambha batch starting from December 27. Sankalp UP PCS J prelims batch started from December 17th. This is your revamped test series for this December. This is your Unacademy subscription, Articulate, coming soon magazine. These are your YouTube channels and the Telegram channels of Unacademy. And that's it from my end. See you in my next class. Till then, yes, it's time to say